Ready? 3, 2, 1, start. Impugned order has been passed by the special judge in an application preferred by investigating agency seeking permission to take voice sample and to conduct polygraph test of petitioner. Stop. In response, petitioner had taken the plea that proposal of investigating agency to take specimen voice sample and conduct polygraph test is against the protection granted to petitioner under Article 20 within bracket 3 of Constitution of India. Stop. In support, reliance was also put on pronouncements of the Supreme Court in cases Ritesh Sinha versus State of UP reported in within bracket 2013 to SCC 357 and Salvi versus State of Karnataka within bracket 2010 7 SCC 263. Stop. Lastly, in the prayer of the reply filed by petitioner, it was submitted on behalf of petitioner that in case the court comes to the conclusion that specimen voice samples and polygraph test are legally permissible, the respondent is ready and willing to undergo the same to show his bona fide. Stop. After considering the law cited and reply filed on behalf of petitioner, learned special judge concluded that the court has power to direct the accused to undergo the polygraph test and give samples of voice where he does not object, with further observation that in present case petitioner has given consent in his reply for these tests. Learned special judge has allowed prayer of investigating agency. Stop para. In this petition also, almost on similar grounds which were raised before learned special judge, the impugned order has been assailed with further ground that learned special judge has wrongly construed the contents of reply to arrive at a conclusion that there was consent of petitioner to undergo the test proposed by investigating agency, whereas the averments made in reply could by no means be inferred as the unconditional consent for undertaking such tests. Stop. It is submitted on behalf of petitioner that readiness and willingness to undergo the test on behalf of petitioner as averred in reply was subject to legal permissibility of these tests and no provision in code of criminal procedure bracket start in short CRPC bracket close provides for undertaking these tests. Stop. Therefore, these tests are not legally permissible and hence conditional consent of petitioner cannot be treated as a consent to undergo these tests. Stop. It is submitted that as per impugned order, apart from violation of protection granted under Article 20 within bracket 3 of the Constitution is also intrusion in right to privacy granted to the petitioner under the Constitution, which is a part of fundamental right. Stop. Shri Desraj Thakur, learned additional advocate general on behalf of state, undoubtedly protection granted under Article 20 within bracket 3 of Constitution, but as laid down by the apex court in its pronouncement in case of Govind versus State of Madhya Pradesh and another reported in within bracket 1975 to SCC 148. No fundamental right is absolute and individual right can be diluted for compelling public interest. Stop. It has been further contended that for scientific investigation. Advantage of technological advancement in forensic science is permissible under law, and petitioner himself has given undertaking for tests in case of permissibility of these tests, and thus now petitioner cannot take U-turn that he has not consented for undertaking these tests. Stop. Over.